Okay, so we're on legislation. We're still on Unit 1, but it's Module 2. Um, so we're going to talk about the difference between civil law and criminal law. With civil law, you can't be arrested for a civil offence unless you keep doing the same offence, then you can. Um, but if it's a one-off occurrence and you've committed a civil offence, the police can't arrest you for it. They normally only take people to a police station to prove their identity if you've got no driver's license or any form of identity on you. With civil cases, they're usually dealt with in a magistrate's court, or if it's in employment, it's going to be an employment tribunal or family disputes court for child custody, those types of things. With criminal law, that's normally dealt with in a crown court, but it starts off in a magistrate to find out um, whether the person's going to plead guilty or not. Okay, so civil laws are usually deal with disputes between people, companies, or other organisations. They'll deal with things like libel or slander, known as defamation in Scotland and other countries, personal injury cases, and trespass. Family and matrimonial disputes, so like I mentioned before, that could be childcare issues, could be divorce proceedings, personal injury cases, employment law, or breach of contract, and the standard of proof is on the balance of probabilities. Okay, and here we are. Trespass. A trespass is committed by someone who's improperly on someone else's property without consent. I'm not sure whether you're aware of this. You know, when you're younger, when you're a kid and you see signs on a gate or on a building site, no trespassing or you'll be prosecuted. You can't actually be prosecuted because it's only civil matter. This is why a lot of businesses hire security guards to escort people off site if they wander on. Um, the only way you can be arrested or prosecuted for trespassing is if they can prove your intent was to commit crime, and they can only do that if you go equipped with something like a hammer, crowbar, something to break into a property. But if you just walk onto a property, you're not breaking any criminal law. It's just a civil matter, and they just escort you off the site. Okay, so a trespass is not normally a criminal offence, not at all, unless they can prove your intention was to commit crime. Can be actionable through civil courts, very unlikely. Is an act or interference against a lawful occupier. Security operatives may ask people to leave a premises if they have no reason to be there. It says break criminal laws next, which we wouldn't do that. There's a mistake on the slides here. If someone breaks criminal laws, then you'd arrest them, wouldn't you? You wouldn't ask them to leave the premises. Break licensing laws, breach specific premise rules or conditions, or they might start to display unacceptable behaviour. React explains the best way to remove a trespasser. So with this, we normally give a person 3 opportunities to leave before we physically eject them. When it comes to working on doors and nightclubs, it's a bit more difficult because of the music. There's normally booming, isn't it, in the background, and you can't hear them, they can't hear you, so it's very difficult. But what you should do on doors, and even if you're working as a retail security officer or on a building site or office block, request for the person to leave, explain the reason for the request, appeal for them to leave and explain what will happen if they don't, confirm that they are still refusing to leave peacefully, then you can take action and eject them physically if you have to. But you're gonna use minimum force and it's got to be reasonable. So if they're resisting, you would apply that little bit of extra force to remove them from the premises, or arrest them if you did have to. If they have committed a crime, then you'd apply that bit of extra force. Here we are, criminal law. Criminal laws are in place to prevent people from committing more serious offences and to punish people when those laws are breached. Offences are usually committed against people or property, and cases are normally brought by the state, so that's the government. Guilty verdicts can result in fines, probation orders, and terms of imprisonment, and the standard of proof in criminal court is beyond reasonable doubt. It's something like 99.99. I'm not sure exactly, but it's still not 100%. There's still that tiny room for error. Okay, it should, in my opinion, it should be 100%. But serious crimes that you might have to arrest someone for are murder, rape, assault, so that's actual bodily harm, grievous bodily harm or grievous bodily harm with intent, sexual assault, possession or supplying drugs, possession of an offensive weapon, firearms offences, theft, fraud, robbery and burglary, criminal damage, driving under the influence of drink or drugs, arson, child abuse or domestic abuse. Working in the security industry, the most common ones that you would have to deal with there are either assault in bars and nightclubs when you're dealing with fighting. If you're working in retail, it's going to be theft, isn't it, for shoplifting. Any of the others are very rare that you would come across them, but not impossible. They can occur. The Private Security Industry Act. So this law was passed in 2001, and the SIA set up in 2004, and the SIA licensing commenced in 2005. That's when we very first started having to get licensed. The Act was brought in to regulate the UK private security industry, help raise standards of individuals and companies, increase public's confidence in the sector, and increase public safety. The SIA is the government's corporate body who regulates the private security industry. The Act allows the SIA to license individuals in specific sectors, approve security companies, so that's the ACS approval, approved contractor scheme. That normally comes up in your test paper as one of your answers. The approved contractor scheme is the voluntary scheme set up by the SIA. They'll monitor the activities and effectiveness of those in the industry, remove criminal elements from the industry, keep the industry under review. They'll conduct inspections, set standards of training and supervision, make recommendations to improve standards. The SIA do carry out inspections. We've had a visit at our classroom, and everything was fine, everything was in order, but they do take their role seriously and carry out checks on training providers and security companies. Okay, so the Equality Act. A prejudice is a hostile attitude towards someone who belongs to a certain group, simply because they belong to that group and are therefore assumed to have all the characteristics ascribed to that group. And stereotyping isn't really discriminatory. Stereotyping is when we lump certain groups of people together, assuming that they are the same simply because they belong to that group. Stereotyping could be something like where people say all Scousers are thieves. It's not fair, is it? We know it's not true, but that's just stereotyping. There's no law that prevents that. Another example could be if you wear a certain brand of clothing, door staff won't let you in the bars or nightclubs because they think you might be a troublemaker. In shops or in bars and nightclubs, there's normally policies where you can't wear a baseball cap. Again, it's stereotyping people really because it's the assumption that only troublemakers wear this type of clothing. But as I say, it's not discriminatory. You can only discriminate against one of these non-protected characteristics. The Equality Act prohibits discrimination based on age, so you can't say to someone, you can't have a job because you're too young or you're too old, because that's not fair, is it? If they've got a disability, gender reassignment, marriage or civil partnership, pregnancy and maternity, race, religion, sex or sexual orientation. So they're the 9 protected characteristics that you can't discriminate when it comes to job opportunities, training, promotions. Okay, what comes up a lot in the the assessment test papers, is a question about a pregnant female, and a lot of people forget that a female having a baby can't be discriminated against. Nobody could sack that female simply because she's pregnant. Okay, so bear that in mind. I don't know what question paper you're going to get, but if that pops up, just remember female having a baby is protected in law. Okay, the Equality Act also applies to recruitment, access to training, pay and benefits, promotional opportunities, your terms and conditions, redundancy, dismissal, or making a reasonable adjustment for employees with specific needs and disabilities. Direct discrimination occurs when someone is treated less favourably than another person because of a protected characteristic they have or are thought to have, or because they associate with someone who has a protected characteristic. So what the law suggests is if you're a white, male, Christian, heterosexual, you can't be discriminated against because you don't have a protected characteristic, you're not the minority. Um, but if you associate with a lot of people who do have protected characteristics, and then you find that you're getting victimized or being treated unfairly or differently, and you can prove that it's based on the people that you associate with, then you are protected in law. Um, okay. But normally it's one of the minority groups who are considered to have a protected characteristic. Indirect discrimination occurs when a policy or practice that applies to everyone particularly disadvantages people who share a protected characteristic. So that could be someone in a wheelchair, and the venue or place that's open to the public doesn't have wheelchair access. That's just an example. There are others, um, but everyone should have the right to go wherever they want, really, shouldn't they? It's also made clear under the Human Rights Act that all people have the right to be free from discrimination. So we all have the right to life, prohibition of torture, the right to liberty and security. So remember, liberty is freedom. When we arrest someone for a crime, and we take away their liberty, don't we? Their freedom. And we all have the right to a fair trial, no punishment without law, and prohibition on discrimination. Okay, the Data Protection Act. Um, so the Data Protection Act came in 1998, and it was updated in 2018, which it's now referred to as the GDPR, General Data Protection Regulations of 2018, and it's about the control of data, images, collection of images in public, and the code of practice, and the 6 principles of data protection. Some of this might go over your head, but I've still got to read it out. It's just the way the legislation is worded and their terminology. Okay, so it has to be processed lawfully, fairly, and in a transparent manner, collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. It should be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. Again, it has to be accurate and, where necessary, kept up to date. And it should be kept in a form which permits identification of data subjects for no longer than is necessary for the purpose for which the personal data are processed. So remember, data subjects are people who are alive. Once a person has passed away, they're no longer considered a data subject. Um, and if it comes up in your test paper, how long can data be stored? The answer is very likely going to be for as long as is necessary. So if you get a question paper that says 30 days, it used to be that you had to over-record CCTV footage after 30 days, but be careful because that's not what the question's asking you. It might not be CCTV footage. It's just any type of data to identify a data subject. And of course, if a crime has been committed, you certainly wouldn't over-record it after 30 days, would you? So bear in mind, if it comes up in your test paper, how long can you retain data of a data subject? The answer is most likely going to be for as long as is necessary. But as I say, it's multiple choice. Just try and bear that in mind if that possible answer pops up. And the data should be processed in a manner that ensures appropriate security of the personal data. With your body-worn cameras, the wearer does not require a CCTV operator license, must be clearly visible to the person it's recording. Images must be downloaded by an authorized person, and images must be stored securely on an approved system. And the camera does not replace the need to complete your notebook or company documentation like an incident report. Nowadays, we're calling them evidence statements. And the reason for that is the case that you've dealt with might not get called up by the judge for a year or two. It might not be a pretty quick case to go through. And by that time, something could have happened to that CCTV footage. It might have been accidentally deleted, or it's been wiped by a magnet. There's loads of things that could happen, and this is why it's so important that you need your backup, which is your evidence statement, just in case anything goes wrong with your video evidence. But an evidence statement is also very important because it's your witness testimony that's being handwritten. So that's one of your primary document evidence documents. Sorry, so you're gonna fill that out regardless. Okay, so if you want to refer back to what we've already covered and make a note of where it says describe civil law and criminal law, and just make a few notes to describe what they're referring to. Identify the key legislation relating to equality and diversity in the workplace. So you need to remember that. And explain how data protection regulation impacts your role as a security operative. What that means is um, what type of data do you process and how regularly or how often do you process it? For example, if you're monitoring CCTV, there's other examples of data that you will process, and I don't want to say it now because you'll just make the notes. You need to look back at what we've covered, and that's the best way to go with it.